off, thank you so much, Sean, for doing this webinar. Here at Trilogy, we do care a lot about our clients and their decisions and their assets and their wishes and all these things. Often they ask me questions about estate planning, and I know some things here and there. I've been in your seminars many times, but of course, I'm not an attorney and I don't feel comfortable giving advice. And that's why you're here and your team is here, trying to make sure that we could answer all the questions for them. And then for all the participants, welcome. We're about to start. And I want to say that after this webinar, you pretty much have 95% of the things that you need to do your estate planning. The last thing is just doing it, and we can't do anything about it. So it's just a call to action after you're done here. Hopefully you take action, protect your family, and do whatever it takes to protect all your assets. So Sean Garner is it's a partner in Decent Garner and Hansen. They only do estate planning. That's why I refer my clients to them and I enjoy working with them because they're highly specialized in this uh, topic, and they have done, I don't know, thousands of these plans for many people, for a lot of clients across the country, not just Arizona. And that is the reason why they're here. Without further ado, I don't want to take time from your presentation, Sean, so just take it away.
Great. Well, we've got a short period of time to cover a lot of information, so I'm going to jump right into it. Can you see my screen okay? It should say Decent Gardner and Hanson with a picture of my building there.
Sean, there is something in the left corner.
Okay, let me move that.
Yes, thank
There
you.
we go. Uh-huh. Okay, so this is where we work. This is where we meet with clients. So we're not just virtual, although we do planning for people in all 50 states. Most of our clients have children that are out of state. So estate planning today needs to cross state borders seamlessly. And that's the type of planning that we focus on is nationwide planning. But this is where we operate. Getting right into it, we think that the easiest way to understand the different options for estate planning is to go through different scenarios. So what we'll do is we've created this family that mimics a lot of the families that we work with over the years and brings in a lot of the common scenarios that we see. And I think that even if it doesn't mimic your clients or you individually, you'll see some patterns that you can incorporate. And so the principles will apply universally. So I'm going to introduce you to Bill and Mary Jones. Now, they're on their second marriage. Bill has a child from a prior marriage. That's John. You can see him off to probably your right. And then Mary has a daughter named Susan. John and Susan are as different as day and night. John wakes up around noon, is always bumming money off of his parents and trying the next get rich quick scheme, can never hold a job, is in and out of rehab, and so not really reliable. Susan, on the other hand, she is an accountant. Her clients revere her as being very professional. She shows up to every Sunday dinner. Her parents could trust her with anything they assign to her. So she is just a very trustworthy straight arrow. So that's our family. Now let's go into what is their estate. They've got an estate. We start out with a modest estate. We want to incorporate um, all individuals. We do planning for the masses. Now, I work with individuals that do high net worth estate planning. They like me to do the fundamentals. And what we're going to go over today is fundamentals that every single person needs, regardless of whether they're worth $1 billion or $100,000. They need to have these basic things down. So we're going to go over the basics. This family has $500,000. It includes a couple vehicles, a house, maybe some stock, and a couple bank accounts. So they're married. They don't worry too much about updating how the assets are titled. They figure as long as they're married, everything will work out fine. So what happens is they go out and they go on a date night, and let's see how this works out. On the way back from the date night, they get hit by a truck. And unfortunately, Bill is killed instantly, and Mary is seriously injured, where she's taken to the hospital. She can't make decisions for herself. And so something's going to need to happen. Now, with regard to Bill's estate, one half of the inheritance is going to go to Mary automatically. Not all of it, even though they're married, because Bill has a child from a separate relationship. And in Arizona, as well as in most states, if you have a child from a separate relationship, then half of the inheritance is going to go to that child of the deceased person. So half of the inheritance now is going to go to Mary, and the other half is going to go to John. Now, she's probably not excited to share half of all of what Bill and her owned with John. So they're probably going to divide up the assets, have to sell the house, divide up the bank accounts, and move their separate ways. In some states, it doesn't even matter if it's a child from a separate relationship, even if it's a child from your sole relationship. Half of the assets goes to that child. Those eastern states like Kentucky and Alabama and Georgia, those types of states have that type of rule. So it's important. We call this intestate succession. You can see that at the top of your screen. Intestate succession is where the state laws govern where the inheritance is going to be distributed. And you don't want that. You don't want the state to determine who is going to receive your inheritance. So let's go and give it a well, let's talk a little bit about court here. So even though there's a distribution and we know that it's going to be half and half married to John, we are going to have to go through a probate. What is probate? So that term, a lot of us have heard it, but how do we define it? Probate is a process of petitioning the court to recognize that somebody is dead and that their assets need to be distributed. So we need to have somebody appointed to be in control of those assets. That person is called the executor or the personal representative. Those terms are interchangeable. And who are the beneficiaries? Who's going to receive the inheritance? So probate courts, they have all of the control. They get to determine who's in control and where the assets go. They, of course, go by state law, but they determine who is going to be the one administering the estate. That's not a very good option. So we're going to give Bill and Mary a do-over. Now, a lot of us have made mistakes and wish we could have this do-over button. In this case, Bill and Mary do get a do-over. So we're going to hit this do-over button and we're going to give them a different try. So let's go. Let's see. Hit the wrong way. Okay. Let's talk about the common versions of estate planning that we have clients come in and discuss with us on a regular basis. The first one is DIY planning. That means the person is very astute. They like to do things on their own. They research them and then they find solutions, whether it's on YouTube or reading up on their own self-help books, and they want to get it done themselves without paying a professional. So to do that, they could assign a right of survivorship for bank accounts and for deeds on their house and vehicles. That's a DIY version of estate planning. The other option is traditional estate planning. And that's generally going to involve either some type of professional or at least going online and going through a program to have somebody walk you through the process and get a traditional will and power of attorney in place. So that's your traditional estate planning, is a will and a power of attorney. And finally, we've got a comprehensive estate plan. And that's where today your an estate plan that's going to incorporate everything is going to be a living trust. It's going to be a will, and it's going to be power of attorney documents. So we're going to go through each of these scenarios with Bill and Mary and see how it works out for them. So number one, we're going to do DIY planning. They talk to each other. Bill, he's an engineer by trade, so he likes to just dig in, read the instructions, figure things out. And he says, you know what, we can handle this ourselves. We don't need to go to an attorney. Let's just do a beneficiary designation on each of the accounts. So we are both either jointly on the accounts or we have got a beneficiary of each other on the accounts that they don't want to blend their assets. Because again, this is a second marriage. We will do a beneficiary deed. Let's say that Bill owned the house before they got married. So we're going to do a beneficiary deed where Mary is going to be the beneficiary of the house after Bill passes away. And then they'll own the vehicles jointly. So either one, if one passes away, then the other will be the sole owner. With that in place, we go through the same scenario. They go out on that date night, they get in the car accident, Bill passes away, and what happens? Well, from a very surface level approach, it works. Mary is going to be the owner of the accounts. She's going to be the owner of the house. She's going to be the owner of the vehicle. So we've avoided the probate scenario in that case. So that seems to work really well. But there's always details, and the devil is in the details. So let's look at the details here. What else do we have to worry about? Mary's incapacity. If Mary's incapacitated, and most Americans, 70% of Americans go through a period of incapacity on average about 2 years before they pass away. So incapacity is something you really need to plan for. If she's incapacitated as a result of this car accident or later on dementia or whatever it may be, then she is going to need somebody to take care of her financial day-to-day decisions. So now we're back in court. This is with a guardianship and a conservatorship to determine what health care provisions are going to be made for her and also what financial decisions legally can be made for her. So a court is going to appoint that. That means, again, loss of control. When people are asked who they want to be their power of attorney, some have a difficult time choosing. And I let them know your worst choice is better than the court's best choice. So make a choice. There's no perfect plan, but don't let the court make the choice for you. The court, of course, has their own schedule, so it's time consuming and it's expensive. Generally, you're going to need an attorney to get involved here. And when there's one attorney, there's going to be two, there's going to be a court appointed attorney. So the fees for this type of thing can get expensive quick. Didn't work out so well. There was some issues there with that DIY planning. So let's get back to a do-over where we do a more traditional estate plan. So they talk about it and they decide we want to do a will. We want to do a power of attorney. We want to do a healthcare power of attorney. We want to get our affairs in order. So let's just get started. Where do we go? So they can go one of two places. They can go online and they can do a Google search for an attorney that does wills and power of attorney forms, or they could do their own version online and just answer some questions and fill in the blanks and have a generic version of an estate plan. So with this, let's talk about what would happen. Go back to the scenario, the car accident, the death, incapacity. What is going to happen? Well, we do get to avoid the guardianship and the conservatorship because we have somebody who's in control, Susan, right? The responsible daughter. She's going to be named as the power of attorney for Mary that's going to be making decisions when Mary is incapacitated. So the power of attorney gives her legal and financial control over those decisions. She also has health care control to decide what hospital mom's going to stay at, what nursing home she might recover in, and also an advance directive that says, at what point does mom want just to die of natural causes rather than be sustained artificially on life support? So those are all in place, and that helps out quite a bit. However, there is a probate in that case, even prior to Mary getting having a power of attorney, because if Bill and Mary didn't put everything in joint accounts, they're still going to have to probate Bill's assets over to Mary's estate. And then when Mary passes away, there's going to be a probate. So there is a will. And many people think that if there's a will, then it's automatically going to go to the individuals named as beneficiaries in the will. But you can't take a will to the bank and say, hey, I'm the beneficiary here, pay me out the bank account or pay my 1/2 share. The bank is going to want an order from the court stating who is in control of the account and only allowing that person to handle the distribution of that account. So it's going to be assured that the creditors of the estate are paid off before the beneficiaries get distributions. So where there's a will, unfortunately, there's a probate. Also, with the probate, it's nice that Susan gets appointed. She is the personal representative, so we don't have to guess who is going to be that personal representative there. My camera just zoomed in, made it a lot clearer, so that's nice. Um, but we still have to deal with um, notices of anybody that is potentially an error out there and go through the probate process. So we're going to have to publish notice in the newspaper for all creditors and any potential claimants on the estate. Additionally, what about John's inheritance? So let's think about this. If John receives his inheritance, there's two options that could happen here. One is Mary could have left everything to her daughter, Susan. Bill's will could have said everything goes to John if I die, and I'm predeceased by Mary. So John is my only survivor. Or we could say it's going to split 50-50 between our two kids either way. I've seen it go both ways. And if John's left out of the will and Mary is the only one surviving, she could name Susan to receive the entire inheritance. And that kind of leaves John dry. In this case, Mary thought it through. So did Bill. They said, whoever is a survivor of us, we're going to split whatever remaining assets there are equally between our two children, even though they're not biologically siblings. So John's inheritance, when he gets his half, what's going to happen to it? Well, the average of how long it takes a beneficiary to spend their inheritance is about a year. Now, in John's case, it'll probably be less, cars, drugs, friends coming out of the woodwork, having parties. It's going to be very quick. And that's sad for Bill and Mary because it's their entire lifetime of what they worked, their legacy, and it's gone in a couple of months, a year on average. Now, Susan's inheritance, we might think originally that's fine. It's going to be taken care of. But let me introduce you to the number one creditor for all Americans, spouse, right? So meet Jason. Jason is Susan's spouse, and he's kind of a freeloader. And when Susan receives this inheritance, he says, "Hey, I'm checking out." Now, if they've been married for a while, then they're probably going to have joint accounts. So everything is deposited in a joint account. And when he divorces her, then he's going to take half of that joint account. If she would have kept it separate as a separate inheritance, she could keep that with her share of the divorce. But in this case, she didn't. She deposited a joint account, and Jason makes away with half of it. So the disadvantages here is we got probate. There's time, there's money, there's lawyers involved. There's no protection of the inheritance, and it also can require multiple probates. So, for example, if you've got real estate in more than one state, then it can require that probate be opened up in a jurisdiction in each state where the real estate is located. Because Arizona, it can only transfer real estate within the boundaries of Arizona. And so if you got real estate in Washington or California, you got to open up a probate there as well. So that's a problem. So we're going to do a do-over. And in this do-over, we're going to explain what the best way to go about getting an estate plan put together is. So first of all, what you want to do is you want to sit down with somebody that understands and will listen to your family scenario and get to know you a little bit and has a background of many hundreds, if not thousands, of other families similar to yours, so they can spot issues that you might run into and point them out to you so they can avoid them in those planning. So we want to learn about the clients, and then eventually we want to provide them with an estate plan that they can take home and sleep on. So we're going to have them give us their best gut reaction as to what they want to have happen in their estate plan, with us asking all the questions and providing all the prompts. But then they walk home with an actual outline that they can say, okay, this is a good starter. It's much easier to revise an outline than to create it. So we send them home with that outline, and this is what it might look like. They've got the names of the important people that are involved. They've got John, they've got Susan. We've talked about the fact that John's got some issues with substance abuse, and he might need to have a little bit of oversight on his inheritance. That Susan is a good choice as a option for either a personal representative or a trustee, and also a power of attorney. So we make those decisions. We put that put it together in an outline. We also talk about the types of assets that are going to be involved in their estate planning. We don't want to bring any documents in right off the bat. Now, coming from you, it might be different. They might have their documents ready to go. But initially, during the first consultation, we want to focus just on the outline of the estate plan. So I'm going to talk about a house or any other real estate that they have. We want to talk about bank accounts, vehicles, anything that has a title, we want to put down on the list and then put down specifically the document that we need to see to make sure that that document is updated in a way that is going to match and align with their estate plan. So then what we do is we create a trust. We write a trust. It's a document, it's a legal document that says, hey, Bill and Mary have control over these assets in this trust, the Jones Trust. And this trust will direct who is in control, Bill and Mary initially, and then Susan when they pass away, so they can have control during their lifetime over these assets and continue having their wishes not only expressed, but legally binding after they pass away. So there's the trustor, that's the creator of the trust. There's a trustee, that's the person that manages the trust. And then there's a beneficiary, the people that benefit from the trust. Bill and Mary are all three when they begin. Trustors never change. Trustees and beneficiaries do. So when Bill and Mary pass away, the trustee would be Susan, the beneficiaries would be Susan and John. So super important point to make here is that you've got to title the assets properly by naming the trust as either the owner or the beneficiary. With a lot of invested assets, you don't want the trust to be the owner because you don't want to trigger any taxes by not having them held in the individual's name. So you can name the trust as the beneficiary, or you can name directly the individuals as a beneficiary if they are responsible enough to receive that inheritance of the 401k or the IRA. But it's important to make sure that the updates are made so the beneficiary designations are done or the assets are titled in the trust. Dirty little secret here is that assets not titled in a trust or a trust without any funding, retitling of assets, is just a glorified will. It has nothing, has no control. It's not going to avoid probate. So we're going to give them a do-over with this comprehensive sit down with an attorney that understands them, puts together this trust. They get in the same accident. Bill passes away. Mary continues to manage the assets in the trust. So when she visits with us, typically what we're going to do is just go over how the assets are titled and make sure that all loose ends are tied up. But we don't need to really change the trust because it's done. And she can concentrate on more important things. Now, when Mary passes away, are we going to have probate? No. So there's no additional expenses, there's no time delays, and there's no multiple probates. We're not going to have to go to different states to do this. This camera is an AI version of camera, so this zooming in and zooming out is all AI. But yes, so the trust can handle assets from all 50 states, and it can give authority to the trustee, who is Susan in this case, to sell those assets or to retitle them in the name of the beneficiary that's designated. So that's what Susan does. She's a trustee. She follows the instructions of the trust and carries out their wishes. How does that look when it comes to John and his inheritance, or Jason and the divorce that is pending? Well, we create trusts so the inheritance stays in a subtrust. It continues in a trust fund for the beneficiary. So John's got his share and Susan's got her share. In their individual subtrust, John's going to have somebody as a third-party trustee looking over the distributions of his assets. So he doesn't spend it all in a couple of months, and it can be distributed over a period of time and in a way that will allow him to be productive and hopefully, get the help that he needs. Susan, in her case, it is going to be a separate asset. The trust cannot be combined with a joint account. So she's either going to make the decision to take it out of the trust and put it in the joint account, or she's going to follow the attorney's advice and keep it in her separate trust account, which she can write checks out of. She can buy a car in the name of the trust. She can buy a house in the name of the trust. She can keep her inheritance in the trust and avoid losing it in either divorce or any other lawsuit or legal action. So that is the comprehensive version and the best possible outcome for the plan for the Bill and Mary Jones family is to have a living trust that also is combined with the power of attorney, to have somebody that can make a legal and decisions, healthcare decisions for an individual if they're incapacitated, and also beneficiary designations for IRAs, 401ks. Those don't go into the trust; those go directly to the individual, or they can pass through an inheritance or IRA trust. And a pour over will is something that we could talk about maybe next time. But what it is a document, it's a catch all that if there's an asset that didn't get put in the trust, it belongs in the name of Bill and Mary, it gets put into the trust because it names the trust as the ultimate beneficiary. So we've got about 5 minutes left, and I want to open it up to questions.
Sean, I do have one question. Some of the participants that I'm seeing there have young kids. How these apply to somebody that has kids? They're still, not 18 and older.
So yes, the many people ask, at what point do I need an estate plan? And the answer is when you have titled assets or when there are people that you are responsible for. And I can't imagine anything more important than determining who would take care of my kids if something happened to me. We talk about life insurance to make sure that they're cared for financially, but you're going to need to have a power of attorney that names who is going to be the guardian of your children if you were to pass away or become incapacitated. And we're going to actually duplicate that in the will. So the power of attorney and the will names the guardians of your children in case you pass away. And you can do a temporary guardianship as well. For example, if you're traveling outside the country, you're going to leave your kids with a family member for a week or two, then you can do a temporary guardianship and it'll expire at the time that you set.
Okay, great. Now, follow-up question. A guardianship, that means who has the money then? So I have three kids and, there's a guardian. The same guardian will take care of the assets or it can be different people?
It can be different people. So in different states, guardianship means different things. In Arizona, a guardianship specifically means authority for the individual, where they're going to go to school, what kind of medical care they get, and the day-to-day just healthcare decisions that are made for them. A conservatorship is for finances. And when we have a trust, we don't really need a conservatorship because all of the assets are in the trust. And so the trustee can be somebody that's named different. For example, I could name my brother as the guardian of my kids because he's got kids that are the same age. They get along, they go to school together, the day-to-day care is going to be fine with them. But I could name my father as the trustee of the estate. So my brother would say, hey, so and so, Sean Jr. needs braces. Can we get a check for that? And that could happen. Oftentimes, it is the same person that's the trustee in control of the funds and named as a guardian, but it doesn't have to be.
Okay, so we have 1 minute and there's one more question saying, what is the average cost of this service? In preparation for this planning, do you share a list of all the pertinent information, documents that are needed to get started?
So the average cost is $3,000 for a single individual that wants a comprehensive estate plan and $4,000 for a married couple that wants a comprehensive estate plan. It's a bit more if you don't. We do an online seminar that basically is a little bit more comprehensive version of what I just shared. And if you watch that, you'll get that price. Otherwise, it's going to be a bit more because it's going to take me more time to explain those options to you. But we don't nickel and dime with our clients. I don't charge by the hour. I like to focus just on the plan and the client. So it's very unique. Some I spend a heck of a lot more time than others, but it's a flat fee. So we both know what we're going to end up with when we're done.
Okay. Are you okay with one more question?
Sure.
Okay, it says that would it be recommended to have someone not family fiduciary as a conservator?
Yeah. So my colleagues where you are in Scottsdale, there a lot of them lean towards banks, financial institution, professional fiduciaries to do that and handle the finances. Um, I tend to lean towards family, but we got to ask questions about how responsible the family is. Banks are going to be cold, right? They're not going to understand the intimate details of your family, but they're going to be responsible. Family members are going to understand those. We just need to know, are they responsible? So it depends on each person.
Perfect. Well, we are right on time. Thank you so much, Sean, for your time. I really appreciate you and your team. I have seen you working at work in your team, and it's a very well defined process. Nothing is to guesswork. Everything I know exactly where in the process everything is, and you're very well organized. And this is very important for something like this because in times of stress, you're grieving, you don't have a head for these kind of decisions, but you can always rely on Sean and the team and the law firm that will take care of you. Again, they're not gonna charge you for just picking up the phone and calling for a quick question. And that's always something that we do care, because times of stress is not a good time to make decisions. But sadly, if you don't make a decision now, in times of stress is when you have to make decisions quick. And of course, this is not one of those decisions. Thank you so much, Sean, for your time. If you have any more questions, feel free to reach out to us or Sean directly and their team. They are going to answer any questions. And until next time, you promise that you're going to talk about pour over wheel, I guess. So I
Right.
guess we will schedule something for the next couple of months. Thank you, Sean. I will see you soon.
Okay. Our website has this seminar. So if you want to get a refresher of it or schedule anything, just go to our website and then you can follow up as you need to.
Right, we'll make sure that we're going to share the details of where to find that and an email. We're going to send this email to all the attendees and everybody that register. We're going to send this with all this information, so we'll make sure that your information is there. Thank you so much, Sean, for your time. Thank you, Adam. Thank you, Carolina. See you soon.
Okay. Thanks, guys.